So now for the main event, I'm pleased to introduce our presenters for today, Matt Linzer and Kim Burke. Welcome to Family Mediation Canada's speaker series today. Matt and Kim are court-qualified subject matter experts in child interviewing and co-founders of Clear Voice Interview Services, which is a firm that specializes in conducting voice of the child interviews and training others to do the same. Collectively, they have conducted over 5,500 court-informed child interviews, and they bring more than 20 years of combined experience in specialized child forensic interviewing roles, along with 45 years of combined experience in child and family services. Given this expertise, Matt and Kim are regularly relied on for their knowledge of interviewing standards, professional oversight, and best practices for incorporating children's perspectives into adult decision-making processes. So without further ado, welcome to Matt and Kim.
Hello, good morning. I'm hoping we are sharing our screen correctly and that the slide is up for everyone. Annalise and Sue, thank you again very much for having us today. We're very excited to be presenting to all of you.
You go ahead, Matt. We can see your screen and we can hear you well.
Okay, however, okay. So welcome everyone. Thank you for being here. We're going to be combining a combination of reading behind the slides, storytelling, as well as pausing for reflection points. Annalise may also jump in with some poll questions here and there. But we want to acknowledge that this is your space. Mediation, dispute resolution, and working directly with families. This is your world and you are the experts. Our goal today is not to come in and tell you how to do that work. Instead, we're hoping to do is contribute to the conversation by focusing on one specific piece of that broader process. How children's voices are gathered, what those voices represent, and what safeguards help ensure that process remains accurate, neutral, and proportionate. We'll be grounding this in research, legislation, and the realities we're all seeing in practice. And really, the goal is to offer a structured way of thinking about this work so that when children's voices are included, they're included in a way that supports both the process and the child.
Good morning. I'm Kim. Matt's not throwing his voice. We'll start out with just some clarification of what is a child forensic interview. Child forensic interview is a structured, developmentally appropriate, and non-leading conversation with a child. It is conducted to obtain accurate and reliable information for investigative or legal purposes. It is not an interrogation. At Clear Voice Interview Services, we're often asked how voice of the child interviews actually work and why they matter so much in family law. Our work is grounded in a child forensic interviewing lens. That means our approach is structured, developmentally appropriate, and intentionally non-leading, with a clear focus on gathering accurate, reliable information that can assist legal decision-making. The strength of this lens is that it prioritizes integrity over interpretation, reducing the risk of influence and increasing reliability, ensuring that what is brought forward truly reflects the actual voice of the child. Our role is very specific. We're not there to assess, diagnose, or provide therapy. We're there to listen, to create a neutral, trauma-informed space where a child can share their experiences in a way that is developmentally appropriate and free from any influence. When we use the word structured, that does not mean that we lead where the conversation goes. The child will always be the one that moves the conversation forward. In a child forensic interview structure means the interviewer is in control of the process, not the content pacing. So transitions, topic shifts, this is all done while allowing the child to freely share their words. Structure should never constrain what the child says, only the organization. So the goal of structure is to create an environment where the child's memory is accessed in the most reliable way possible, reducing interviewer influence while supporting the child who may be anxious, confused, or reluctant to communicate fully. The interviewers are trained to move from open-ended prompts, which will allow the child to complete freedom to narrate. Structure decides when and how different discussion points are introduced. So our responsibility is really to faithfully and accurately bring that voice forward to the decision makers. And collectively, we've conducted over 5,500 child forensic interviews, and that depth of our experience, it informs every interview that we complete. And we rely on evidence-based, internationally recognized protocols, which prioritize careful question structure, child development, and also the integrity of the information being gathered. We recognize that we are only one part of a broader professional landscape. There's therapists and counselors, lawyers, mediators, and they all play essential roles. Our contribution is distinct. We approach this work through a forensic lens, focused on obtaining clear, unbiased information. We do that rather than providing intervention, interpretation, or treatment. So in Alberta's family law space, this does fill a critical gap, and we approach it with a strong commitment to neutrality, professionalism, and the belief that every child deserves to be heard clearly, safely, and without any bias. So if you work in the family law or dispute resolution and want to better understand how the child forensic interview informed voice of child interview works, we could be more than willing to connect with you at a later time.
So, what we're seeing across the family law and mediation landscape is a clear, growing expectation that children's perspectives should be included in decisions that affect them. This is being driven by legislation, research, and evolving professional standards. There is a broader recognition that decisions about children are stronger and more sustainable when their experiences are understood and considered. Alongside that, we are seeing a shift not just towards thinking about children, but toward actively including them in the process. And that distinction is important. A child-focused approach means that professionals are thinking about the child, considering their needs, and trying to make decisions in their best interests, but often doing so based on adult perspectives, interpretations, or assumptions. A child-inclusive approach moves beyond that. It means that the child's actual voice is brought into the process in some structured way. So we're not just talking about the child, we are in some form hearing from them directly. That doesn't mean children are making decisions or being placed in the middle of the conflict. It means their experiences are informing the process in a way that is developmentally appropriate and proportionate. So the shift we're seeing is really a move from indirect understanding to direct, but carefully structured inclusion. At the same time, mediation continues to expand, placing many of you on the front line of these decisions. Despite this shift, there is still uncertainty in practice, particularly around when, how, and to what extent children should be included. And that's really what we're talking about today. Let's take a brief second to reflect about the difference between inclusive versus focused. So reflect on a mediation where the child's best interests were considered, but the child was not directly included. How might that have influenced the outcome?
Including children is not a new concept. So at the international level, Article 12 of the UN Convention of the Rights of the Child, it's very clear. It states that children have the right to express their views in all matters affecting them. And those views must be given weight based on the child's age and maturity. So importantly, it goes further. It requires that states shall assure that children are provided the opportunity to be heard. So that language really matters. Shall reflects an obligation, not a suggestion. It signals that this is not something to be considered only when convenient or when it may align with a particular process. It's intended to be a consistent part of decision making wherever the children are affected. It's embedded within that is a second important idea, not just that children can speak, but that meaningful opportunities must be created for them to do so in a way that is appropriate and safe. This is also not intended to be something that is only reserved for litigation or court-based processes. The right to be heard, it applies broadly, including in early decision-making, mediation, and other forms of dispute resolution where outcomes are being shaped. But while the principle itself is clear, how that obligation is being implemented in practice, it continues to vary. So across jurisdictions and even within the same system, we're seeing differences in when the children are included, how their voices are gathered, and how those views are actually ultimately used. So the right itself is very well established, but the process for realizing that the right is still evolving.
Let's talk about practice tension. So in practice, there is a natural tension. Professionals, particularly lawyers, are operating within an adversarial system where their role is to advance a position on behalf of their client. So when a child's voice aligns with that position, it may be welcomed and brought forward. But when it complicates that position or introduces uncertainty, there can be hesitation. This isn't about fault or intention. It's about the structure people are working within. What that structure can lead to is a form of selective inclusion, where the child's voice is introduced when it supports a position and potentially minimized or avoided when it does not. We're also seeing a similar dynamic in mediation. In some cases, agreements are reached and considered successful without the child's voice ever being directly included, sometimes out of concern that introducing it may disrupt progress or create additional complexity, and in other cases, inclusion was never built into the process from the onset. But this raises an important question. If the inclusion of a child's voice is dependent on whether it helps or hinders resolution, are we treating it as a right or as a strategic consideration? When inclusion becomes conditional in that way, we move away from the principle behind it. Children's voices are not meant to be something we use to strengthen a case or something we avoid to preserve an agreement. They are meant to be considered as part of the process itself. And so the challenge becomes how to move from selective inclusion to consistent, proportionate inclusion in a way that still respects the roles of the professionals involved.